Hello, everyone. My name is Vicki Townsend. Thank you so much for being here on the CafeD. We are here today with Divorce RX. It is our mission to bring you the best experts in the divorce process so that we can help you actually be prepared for the process, whether it's before, during, or after your divorce, so that we can help you with some problems and situations that might come up so that we can save you time, money, and your sanity. So thank you so much for being here. We have an amazing friend, and now she's going to be joining with us as we bring Confessions of a Former Divorce Attorney to you each and every week. And today she's going to be here. We're actually talking today about going to court, what that looks like. Why is that important? It's important because we want you to be prepared. When you are prepared, when you know what's coming up, and you understand the process, you can save yourself all sorts of time, all sorts of angst. We don't want you to be upset and anxious. We want you to be ready and confident. So that's what this conversation is about today. So thank you so much for being here. If you would like to talk to Sonia live after this webinar is over, just join our membership group. It starts at just $7 a month, and you can have access to industry experts like Sonia, but not only divorce attorneys, but we'll have accountants if you have tax questions. We'll have financial advisors. We have marriage and family counselors. We have child psychologists. We have real estate agents and insurance agents and mortgage companies and private investigators. Gosh, we have even people that'll help you sell your jewelry. So we have everything that you're going to need as you go down this road, because I've been down this road. I'm with you. We have your back. We're there for you. So go over right now to thecafed.com and join our membership really quickly. It's not going to take you much time. And join us in our private Facebook group after this webinar is over, and ask all the questions that you need. We'll get those answered for you. So let me tell you a little bit about my friend Sonia. Sonia Kuralt is the founder of Divorcify. It's a really cool thing. It's a multidisciplinary concierge service that provides customized coaching, strong support, resources, and an organization to those who feel overwhelmed by the logistics and shock of the divorce process. Divorcify's mission is to empower people navigating through a divorce. The goal is to maximize results and prepare clients to emerge and succeed in their new life, whether the goal is to obtain custody, receive alimony, or achieve other specific goals. Divorcify helps clients achieve their goals. So that's where that private divorce coaching will come in to help you actually move your divorce through a process easier and gentler. So welcome, Sonia. How are you today?
Hi, doing so well, Vicki. So always a pleasure to be here.
I'm so excited about today, and I say excited not because it's a great thing, right? Because it really stinks. Let's just say it out loud. Divorce sucks. But the great part about what we're talking about today is your day in court. And what's really the best outcome of what we're about to do is, because when people are going to listen to this and watch this, whether you're in the privacy of your own home or whether you're at the office today, whatever you're doing, by the end of this half hour, you are going to be able to be better prepared for your day in court. And you were talking to me earlier about your first day in court doesn't necessarily have to be the day that you show up with your divorce attorney, right?
That's absolutely right, Vicki. And I think this is just going to be so helpful for a lot of people, getting a little bit of behind the scenes of what us lawyers already know going into court, but our clients clearly do not. So no, your first day in court does not have to be with your divorce attorney. I actually, when clients were very anxious about going to court, I would tell them, you know what? We know who the judge is. We know what courthouse you're going to be in and what courtroom. Go observe the judge on their motion session. It is public. You can walk right in. You turn off your cell phone as long as you're sort of just quiet. You can sneak in the back. But it really gives you a feel for what your day in court's going to look like. And it also allows you to get a feel for your judge. Because I've said this multiple times, but you can have the same set of facts and the same set of circumstances and the same legal arguments on the same day and get two in front of the same judge and get two different results. So just being able to be in the courtroom really it allows you to know what to expect when it is your day in court, and it allows you to manage some of that anxiety because now you know what the process is going to look like.
Let me ask you a question about court. First of all, is there some statistics on people that actually get to court? Is that I know here in Florida they really try to minimize the getting to court. So they make you try and go through mediation. They make you go through all of these hoops before you get there. Is there a percentage of cases that actually go to court, or is there a different thought behind what that looks like?
So I'm sure there is a percentage. I don't know what that is, but I think to talk about two different things. One is trial, sort of what we see on TV with witnesses and both attorneys are asking questions. Trials are very, very rare in a divorce. Very rare. One, they're extremely expensive, they're extremely time consuming, and that's when your client's being prepared as a witness. So there's a lot of preparation that goes into it. Most cases, most divorces settle on the courthouse steps. So you're going to prepare for trial if you haven't settled, but you're not going to go to trial. Now, going to court and what we're talking today in sort of a motion session, at least here in Massachusetts, unless the parties can temporarily come to an agreement, lots of times we're going to court one or two times to put temporary motions in place, whether it be a parenting plan, custody plan, removing somebody from the house, from the marital home, child support. So it is a short session, but a lot of the divorces, I would say the majority of my clients, we ended up having to go to court at least one time, and then to present the agreement.
Yes, and so we are talking today about those types of things. We're not talking about trial. We're talking about going to court. So what does that day look like? What time should I get to court? What's that going to look like?
Absolutely. So at least the way it works here in Massachusetts and in most jurisdictions, what you're going to get is you're going to have a time to be in court, 8:30, let's say. But what you have to remember is that you have that time, and so do 30 other cases, at least. So just because you get an 8:30 time, be prepared for a long day in court. So the assumption is that before your court date, you've already talked to your attorney about where to meet. Because if there's such a thing as a restraining order in your case, you will probably, for safety reasons, want to meet with your attorney somewhere by the courthouse, but not at the courthouse, just in case your spouse walks in. That tends to relieve a lot of anxiety. So whether or not you're comfortable or there's a restraining order, you may want to meet somewhere outside near the courthouse. Otherwise, my clients and I like to meet right past security. It's clear. We go up to the courtroom together. I like to get to court early. The reason is because you have to check in. So the earlier that the parties are there and the earlier that you can check in, and by checking in I mean you're going to go with your attorney up to the courtroom. You may wait outside. You may just sit in the courtroom. Your attorney will go up to the judge's clerk, which is usually their right-hand man or woman. They are the judge's eyes and ears, and they can be your best friend. So always be nice to everyone, but especially be nice to the clerk. And what your attorney is going to do at that point, they're just going to be filing paperwork. And the paperwork they're going to be filing, your updated financial statement, any last-minute motions that have been written, a notice of appearance, which just makes it official that your attorney is appearing on your behalf. So it's a lot of housekeeping. And they're going to go up, check in with the clerk, and pull anything from your file that they need to view. So that's what's going to happen initially when you first walk in. So getting to court early is very important.
Okay. So, and also I'm sure that you're going to be really kind of nervous. So, and we want to make sure that if there's a parking garage or, just make sure you have change and that sort of stuff for your street parking if that's going to be the case. So we've talked about like where you meet your attorney, but what will your attorney be doing prior to that hearing starting? I mean, what does that look like? Is he or she with you? Are they in a different, do they kind of, are you left in a chair somewhere by yourself? What does that look
Sure,
like?
that's probably this is the biggest and hardest part for clients. So your attorney will, it obviously, all of this, we're assuming that both attorneys on both sides can work together. We're assuming that we're close to some agreements and we're negotiating back and forth. There are times that attorneys will not speak to each other until they get in front of the judge. But the majority of the time, your attorney is going to be speaking with the other side's attorney, your spouse's attorney. What are they talking about? Well, any sort of logistics that have changed, or facts that have come up, or situations, anything that we're close to agreeing on, so that when we get in front of the judge, we can say, you know what, Your Honor, we've actually come to an agreement on these 4 issues, and the only one that we need some guidance with is one of them. What we're really trying to do is, you don't want a judge, a stranger, who is listening to 30 and some odd cases a day, making a decision on your life. That's how I tell my clients, the more we can agree on, the better. Because if you're agreeing to something, there's a level of empowerment in that, and there's a level of control. And when we leave everything up to a judge, we can make the best arguments, we can have the law on our side, but at the end of the day, the judge, out of context, is making a decision that will affect you and your family temporarily until the following court date. So there's going to be a lot of back and forth with the attorneys. The attorneys may check in with you, because no attorney is going to go into an agreement with the other side without notifying you of any proposals. So yes, you may be spending some time alone. If I have clients who are very nervous about that, I tell them to bring a friend, somebody they trust. That way, as I'm sort of going back and forth and not able to give them my complete undivided attention in terms of helping them with this emotional and anxiety-ridden part of court, they have somebody there that they trust and are comfortable with. And it's also another set of eyes and ears, because when you're so nervous, sometimes you don't hear what you think you hear. And so there's a lot of that. So you may be alone, your attorney may be next to you, but odds are they're going to be going back and forth a lot with the other side.
So what happened? So you're getting ready. What actually happens when your case is called?
Sure. So your case is called. You are going to go up to either a table, or you're going to go up to sort of a podium. Some judges actually get you a little bit even closer to the bench, and they have a podium there. At that point, you're going to be standing there with your attorney. Now, if there's a restraining order, again, there will be a court officer that will be right behind you because of the restraining order, to just protect you and for safety reasons, because your spouse and their attorney are going to be up at that podium as well. At that point, the judge will have everybody introduce themselves, including the client. So you will be speaking. You will just be introducing yourself. The attorney will introduce themselves. Then it's up to the judge. Some judges have reviewed the file, and they may get right to some questions that they have. Other judges may just hear from the plaintiff. The plaintiff is the person who has filed the motion. So whoever has brought this in front of the judge, they will be first to speak. Their attorney will be first to speak. At that point, the defendant will be able to respond to whatever the first argument has been made by that attorney. And in between this, the attorneys are fielding questions from the judge. Now, I like to tell my clients when we go into these sessions, odds are you will not have to speak except for introducing yourself. There are times, though, to be prepared, a judge may just want to hear from the client, and they may just ask you a direct question. So be ready. If you don't understand it, if you're nervous, take a second, take a breath. It's okay. But there is a possibility that the judge may engage you in short, but a conversation to get some more information directly from the source as opposed to your attorney.
So what would be some, because that can be kind of nerve-wracking for a lot of people, even the thought that you're going to be talking to a judge, because hopefully that's something that you never have done before and you never have to do again. But is there like some sort of relaxation exercise or something that you can do to get people out of the nervousness of that moment so that they can focus on what they need to do and do it with grace and some dignity without feeling and looking and falling apart?
Right, of course. It's so hard. I remind my clients, because a lot of them will look at me and say, well, what do you think they're going to ask? I said, whatever they ask, it doesn't matter, because you always tell the truth and it's your story. So to really, also, I like to do it as an attorney, take a breath, and in my head, I count to 10. I take a deep breath, I count to 10, I focus, and it just helps me focus and get to the response quickly. Why? Because in these sessions, you will be in front of the judge. If 10 minutes, you're lucky. The judge is hearing case after case after case. So there's not a long time for long-winded responses. It's fast. You want to get your point across, and you want to really focus in on what are your priorities. What do you want to come out of that court date with? So for the client, I think just remember, it's your story. You don't have to remember anything. You don't have to. It's your story. Answer the question. If you don't understand the question, don't be afraid to say, Your Honor, could you repeat that? It's okay. It's okay. We're all human. You can do that. Count to 10 and then just respond and get right to the point. Get right to the point. That's what the judge wants.
So listening is key in that whole breathing and being centered, right? And just being able to focus. It's about listening to what's asked and just giving that answer. You don't need to go off on tangents. As a matter of fact, it probably would behoove you to not go off on any tangents other than what the judge wants to know, right?
Yes. Yes, 100% yes. You also, as lawyers and as clients, you really want to get a feel for the judge. There are days that the judge, maybe they didn't have a good breakfast and they're not in the mood and they want to get through it. You have to read that, because if you're going to start giving long-winded answers, judges will shut you down. For attorneys, they will stop your argument, and as clients, they will try and get you right to the point. So really knowing your audience. If your judge is patient, if they're asking follow-up questions, by all means, explain. But otherwise, just answer what's being asked. That's all I ever tell my clients in preparing them for a deposition, for court, for anything, for a meeting with the other side. Just answer what's asked. Nothing more and nothing less. And I think that's just right, is just getting right to the point. So make sure you're listening, you understand the question, and respond to it.
What happens, so here you are, you're in court, you're standing next to your attorney, your spouse says something, and you need to give feedback or tell your attorney something during that procedure or during that court hearing. How do you do that? What happens? What does that look like?
Absolutely, and that happens a lot. And so the best way to do it is, and as an attorney, I always have extra legal pads with me. And I'll give one to my client, and I will let them know if there is something that you want to tell me or you want me to respond to a certain argument, because as attorneys, we're prepared for a lot of the responses. We've had some back and forths with the other side. We know what their positions are, so nothing will really be a surprise that day. But if there's something that the client specifically wants me to respond to or a piece of information they want me to have, write it down. As an attorney, and I'm sure we have some listeners out there that are divorce attorneys, there is nothing more distracting. And remember that all eyes are on the attorney, the client, everybody's watching us. There's nothing more distracting than to have a client sort of pulling at your shirt, whispering in your ear, trying to get because what you have to understand, as attorneys, we're triaging a lot. We're reading our audience, we're responding to the judge, we're focused on the arguments we need to make in order to get you what you need and want. And most importantly, I want you to keep your dignity and confidence. And if you're yanking at me and you're pulling me and you're giving that sort of visceral reaction to something that shouldn't be very unexpected from your spouse, and if it is, or from the other side, write it down. The more calm and the more you and your attorney look and feel like a team, the more organized and the more efficient, and just, I don't want to say there's a level of respect, but there's a level of confidence that you and your attorney have that can go a very long way. So write it down and pass that notebook right over. And I like to, if they have multiple questions, put your finger on the question that you want me to read, or the information you want me to see. And that is so beneficial, because then I can see that, I know exactly where to insert it, and I can continue without being distracted and unfocused.
So does that look like, so are you typically standing? So in my case, I was sitting. But are you typically standing, or are you typically sitting? Or does it matter?
Sure. Sometimes it depends on the judge, and honestly, it depends on how long the argument's going. There are times that you sort of start standing, and then the judge sees that this is actually going to be a little bit longer of a hearing, and they will let the parties sit. Most of the time, I'm standing as the attorney, and my client is sitting.
So if I'm going to write you a note, I'm actually going to use this term, like, is it like passing a note in high school? You know, do you like me? I like you. What what does that look like? Is it kind of like under, you sit there and you try and kind of casually you know, or is it expected? Like, does the judge expect you to pass a legal pad to your attorney? Is that regular and standard, you know, things that happen in a courtroom?
Yes. In my experience, absolutely. You don't need to, and I'm glad you brought that up.
So you're not going to...
Yeah, no, I'm really glad you brought that up. You don't need to hide it. It's not like high school, behind the back, through the desk. No, no, no.
Right.
It is standard practice for clients and attorneys to not only take notes during the hearing. I tell all my clients, take notes. I'm taking notes, but I may be missing something. You can take notes as well. And if you have something to tell your attorney, it's completely okay and standard practice for you to write something on a yellow legal pad or whatever notebook and just pass it right over. Not a problem at all.
So you know, and this would be something that I would envision happening, and probably happening a lot, that your spouse says something that really just sets you off. You know it's not true. You know it's inflammatory. Whatever happens, that, you know, for me, I'd be going, you know, and so again, that comes back to the breathing.
Yeah.
Right, nicely. Don't get over, because the judge will be able to read that in you as well.
That's
so right. Is there a way that if your spouse like says something that you just want to call BS on it, right? You want to say, what? How can you do that without losing your cool?
I know.
That's
so hard. And I tell my clients, you're allowed one of these. You're allowed to lose your cool on one time, because I very much understand. And it's really hard because you're hearing things that are completely untrue. Number one, remember, the judge has heard a lot of this before. It is clear to a judge and to people there that somebody is really trying to use inflammatory accusations just to rile you up. So if they think that they're saying things and nobody's picking up on it, they are. Number two, shouldn't surprise you at that point, right? That's what I like to tell my clients. It's sad, and that's a really hard place to be, but it shouldn't surprise you. Let crazy be crazy. You focus on why you're at that hearing today and what you want to come out of it. So some clients start to just sort of write on the notepad, or some of them are just circling things on the notepad. That's absolutely fine. I think maybe Vicki? I think we may be
end of the court hearing.
There we are, Vicki. I'm sorry I lost you for a second. So I'm sorry everybody, it looks like we're having a little bit of technical difficulties, which it happens.
Yeah, we've got a little bit of technical.
That's right. So we're having a little bit of trouble hearing Vicky, so I'm gonna just sort of continue and hopefully we can get her back on shortly. But there is, you know, when you are at the hearing, just remember your spouse is saying things that are inflammatory and hurtful. Really just focus on why you're there. If it's for your children, you know, you just have to let some of those things go. Afterwards, what I like to do with my clients, I very much like to debrief with them. I always debrief with them after a hearing. I think it's important on two fronts. Obviously, there's a lot going on that court date. You want to make sure that everybody understood what went on and what the judge ordered. Because what the judge ordered, even though these are temporary orders, and the reason they're temporary is because they're from this first court date until the following one. Judges do that for various reasons. Sometimes they do it because they want to see how a parenting plan works. How is this arrangement working out? So you know what? Let's give it a few months and let's come back and reassess. But you really want to understand what that order says, because that is what you're living under for the next X amount of time. And if it's not working, you need, Vicki, are you back? Not yet. Okay. So, and you really want to understand that because you don't want to be in violation.
Can you hear me?
Now I can, Vicki.
Can you hear me?
Yes, here she is.
Okay, let's see. I understand.
Think we're still having some technical difficulties, which is okay. So so that's very, very important, is to not violate court orders for two reasons. One of them is because you can't violate court orders. Number two, also, you don't want the judge, you want to go back to court with clean hands. You don't want to go back to court because you've been violating the order. That is going to show lack of judgment, lack of respect for an order, and you don't want to be in that position. If your spouse puts themselves in that position, great. You get to go to court in clean hands. You then get to tell the judge at the following court hearing. Your lawyer will be able to tell the judge what's been working with the temporary orders, what hasn't been working, and that will, and then you'll sort of manipulate things so that you can really live under guidelines that work for your family. That is what's most important. These guidelines are for your family. It's not just for you and for your spouse, it's for your children, it's for your family unit that is changing and the roles are changing. But what you really want is to be able to let the judge know this has worked, but this hasn't, and adjust and try to agree with the other side. So debriefing after court is something that I do with all of my clients, and I think it's very important. It also gives clients the opportunity to ask any and all questions. There is so much that goes on in court. It's almost it's overwhelming. It's completely overwhelming, and it's a new process. And there's a lot of legalese that us attorneys use when we're making our arguments that normal everyday people may not understand. That's your opportunity. Sit with your lawyer. Ask them questions. Ask them questions about their strategy. Why did they choose to not talk about this, but to talk about that? You really want those open lines of communication between you and your attorney. That's your advocate. Your attorney is your mouthpiece. Your attorney is who is going in front of that judge and making arguments and advocating for your best interest. So you really want to make sure that you understand everything that went on that day. The more you know, knowledge is power. I had it backwards. Knowledge is power. The more knowledge that you have about, Vicki, there you are.
You know, this technical stuff sometimes can get the best of me, but thank you so much for taking on that the last couple of minutes there. But, you know, I don't know if you heard that last question that I had for you, Sonia, which, you know, really was about what the end of the court hearing looks like. Were you able to talk about what happens at the very end of your court hearing?
Sure. So I just talked, I talked about debriefing with, I debrief with all of my clients at the end of court and why that is so important. But at the end of the hearing, the judge may do a few things. They may make a decision, and if they make a decision, they are handing down an order, and that is what you will be living under temporarily until your next court date. Sometimes, and I hate to say this, but it happens very often because our courts are very backed up and there's not enough staff and the judges hear a lot of cases. The judge may reserve their decision. So what does that mean? Both attorneys have made their arguments, the judge has asked any and all questions, the hearing is over, and the judge has made no decision. And what they're going to do is write up their decision, and your attorneys will receive it in the mail in a few days or even a few weeks. So there is this limbo, a time that is extremely hard for our clients, and that is when you need your team around you more than ever. So that can happen. So just because you're going to court, don't expect a decision. It could be that the judge does not issue a decision that day, and that is why. So if you hear that, that's a tough day. And it's a tough day for us attorneys because we want a decision for you. So it's not easy on any front, but it is a possibility, and in my practice was happening more and more.
Okay, well, I thank you for that, because I think that what we've been able to do here is to help anybody that's listening to this at least prepare for what that day is going to look like and how it's going to feel, because it feels, the stress and the anxiety is kind of a part of the process. And hopefully, even the tip that you gave about going to that divorce attorney before, I mean, not the divorce attorney, your judge, before you even get to his or her courtroom is a brilliant idea, because the more you can do to reduce your anxiety and your worries and your concerns, and the more you can get familiar with the situation, the higher the likelihood that you're going to be in control when you're in that room. Right. And that you're not going to experience what you think you're going to experience. It doesn't have to be bad, and knowledge is power. And that's why this is really important, because this is knowledge. This is what we're trying to do here. And speaking of what we're trying to do here, we're at the end of our half hour. We want everybody to go over to our private Facebook page and Facebook group and join us for your Q&A over there. But one of the things that I want to talk about is you and I are going to be starting the Confessions of a Former Divorce Attorney, where we're going to do some group divorce coaching, right? And we're going to open it up. We're going to open this up for our members for free starting right away. We are going to do it as a part of our CafeD membership for a couple of months. We're going to set the parameters up pretty soon. So anybody that knows anybody that wants to go through this process, is thinking about going through this process with somebody that will be there to hold their hand a little bit in a group setting, so it will be financially, super affordable for them. And right now, as long as they're a member of the CafeD, which starts at $7 a month, they can hop on these calls. They can be every week. We're going to be talking about what this process is like. You can ask your questions right there, and other people can listen so that they can learn, and you'll be learning from other people that are going through it too. The idea for us is to get you there, as financially soundly, saving you time, money, and your sanity. So look forward to that. It's called Confessions of a Former Divorce Attorney, and Sonia will be on that each and every week. So we'll be posting all about that on Facebook and Twitter. We'll sign up for our email list, and we will get you all the information on how you can get onto one of these calls with us directly. But meanwhile, it is we are into this by over half an hour. So let's go to our private Facebook group and ask and answer some questions. So thank you so much, Sonia, and we'll see you next time. Bye-bye, everybody.
Bye-bye.